Stalking statutes in Florida have evolved over the years along with the cluster of domestic violence laws and temporary restraining order laws, this quasi-criminal civil action that can be taken to protect people from crimes such as stalking, which is a willful, malicious, and repeated following, or now cyber-stalking, of another person. That's right, cyber-stalking. That's engaging in communication or causing a communication of language, words, or images by using electronic communication or electronic mail directed at a certain individual, which serves no legitimate purpose and causes undue emotional stress to the person receiving such communication. All right, well, that's the legal definition right there. But in reality, anytime you have a perpetrator who is using electronic means, whether it's a computer, cell phone, text, they're using these electronic means to harass, embarrass, or hurt you or your business, then Florida law gives rise to remedies. And these remedies can extend pretty far in certain circumstances and in cases where you have the right judge who's willing to push these protective statutes as far as they can possibly go. Stalking can mean many things, including following an individual, sending letters, notes, emails, objects, gifts, text messages continuously, as long as it's all done with a malicious intent or sticking to a pattern of undesirable behavior. Sounds pretty vague, but it's the fact that they are vague which makes these set of Florida laws so powerful, and then by the same token, so threatening for the individual who is named as the respondent, who the allegations are against. Let's talk about the criminal penalty for stalking. Stalking is only considered to be a first-degree misdemeanor offense, punishable with a fine of up to $1,000 and or up to a year in jail sentence. However, Florida law also distinguishes the severity of stalking based on certain circumstances and can raise the charge to a third-degree felony. Now you're talking about prison and up to a 5-year mandatory sentence. And of course, the fines of $5,000. In addition to stalking, though, we have the TROs, the temporary restraining orders and no contact orders, which also give the court significant power to restrict a violator's liberty. This can get pretty messy for a respondent when you add it all up. But before you try to wrap your head around TROs and domestic violence and stalking and how they all fit together, let's just stick with Florida criminal charge of stalking. Once again, stalking starts off, it's the base model, if you will, is a misdemeanor. But stalking, of course, can be aggravated. Stalking can become a felony offense when the accused credibly threatens to cause bodily injury or death of the victim. Minors are protected under the statutes. Minors being children, individuals under 16 years old. Remember, persistent, repetitive behaviors are significant under Florida statutes that govern stalking. In 2012, the definition for credible threats was changed under Florida statutes to include all kinds of verbal and nonverbal threats and pattern of conduct that would be construed as a threat by a reasonable person. The changes in the statute have also eliminated the requirement of intent from a credible threat, making it easier for the victim to file charges and for the prosecution to convict the accused. Unlike in assault charges, when it comes to stalking, the state attorney's office is not required to prove whether or not an accused had the ability to carry out threats that were made. Now, one of the things that is particularly interesting about an effect of the evolution of stalking statutes and TROs and the prosecution of same is the blend, the mix that criminal defense attorneys found themselves in with regard to representing victims. Generally, criminal defense attorneys only represent the defendants charged with crimes, the accused. But you started seeing more and more criminal defense attorneys taking on cases to assist victims of this behavior of an ex-boyfriend, ex-girlfriend, husband, family member. Now, looking at the prosecution's obligation, we acknowledge that in order to build a strong case, the victim should first make reports of the behavior to law enforcement whenever this behavior takes place. In order to prosecute an offender, naturally a prosecutor will have to present a threshold amount of evidence. But remember, you have the temporary restraining orders that have a lot of bite, because once those temporary restraining orders are put into place outside a prosecution for stalking, and they are put into place by cautious judges who don't want to make a wrong ruling and protect an individual who's filed and met the very bare minimum threshold, which will allow the court to issue an order preventing a perpetrator from coming near the alleged victim. That opens up a whole world of remedies to the victim should the stalker violate. Now, of course, you're going to hear from law enforcement that victims should keep detailed records, notes, photos, phone messages. But if you don't have those things and you are a victim, you may find that these cases can grow into something that are quite effective with or without a prosecutor's ability to proceed criminally under the stalking statute. Applications for a petition, an injunction, can be filed with the clerk of court. And victims should always do this if the threat is real. Relying on criminal statutes is not nearly as effective due to the constitutional rights that are afforded. But under the injunction statutes, small steps are made. And remember, you can file for an injunction even against cyber-stalking, harassing behavior via electronic means. A far cry from domestic battery, where these TROs originated from, a far cry from stalking statutes, which we're talking about right now. Remember, Florida courts are authorized to issue injunctions protecting a victim for a significant amount of time, up to 10 years. Should an accused violate, these judges will take action in the form of incarceration immediately. In the next section, I want to talk to you about the more important element of temporary injunctions and permanent injunctions used in stalking, cyber-stalking, domestic violence, and the power that stems from the judge's complete leaning towards granting this type of remedy for victims that just make the bare bone allegations. I think you'll be surprised to see what allegations are required. How are you, baby?
Good. I just made our bed. That's cool.
Yeah, that's cool.